Streets coming down.
Yeah.
I'll tell you what, looking on screen, there's some difference between the color of Will's head and Tom's.
Welcome to the host Judiciary Committee. We are live now. This is Wednesday morning, March 20th, and we're going to start with a quick walkthrough of S190. Thank you for being here, Michelle.
Good morning. So for the record, Michelle Childs, Office of Legislative Counsel, and we're looking at S190 as passed by the Senate. And as the chair mentioned, it's going to be super quick because I have to be downstairs on all those bills that you sent over to the Senate. I have to be down there at 9 o'clock this morning to walk them through a few of those. So S190 is amending the court rules. So just want to set the stage there for that out front and let you know that just like you can access Vermont statutes on our legislative webpage, there are also links there to access the court rules if you would like to link onto those and look at the court rules in full, because I've only excerpted the parts that I'm amending in here. So there's three substantive sections here. Two are amending the court rules. The first one is amending the rule with regard to depositions of minors. And the second one is relating to admissibility of hearsay statements. So section 1 amends the Vermont Rules of Criminal Procedure with respect to depositions. So just as a little refresher, deposition involves the taking of a sworn out of court oral testimony of a witness that can be reduced to writing a written transcript for later use in a court or for discovery purposes. And discovery means basically investigating the evidence that the other side plans to present. So currently there are special rules regarding depositions of children who are under 16 years of age if they are victims of certain sexual offenses. And as what S190 does is extends those protections to children under 16 years of age if they are victims in a case of cruelty to a child involving serious bodily injury. So if it's helpful, I can probably do a little document that I can send for posting on your website that will give you kind of like the links to some of these statutes that are referenced. So you do have, I think you've probably worked a little bit with the cruelty to a child statute. There's two provisions. There's a misdemeanor offense of cruelty to a child, but then there's also a felony offense if it causes serious bodily injury. And I can also provide the definition, the link to the definition for you for serious bodily injury, but I know you're somewhat familiar with that term because it is used throughout Title 13. So if you look at the language that's on page 1 of the amendment, you'll see it's amending the subdivision E5 on depositions of minors. And so you'll see the current process and the offenses that are listed there. So as I mentioned, those protections currently extend to a victim under the age of 16 for certain sexual offenses, and this would be expanding it if the offense that is charged is cruelty to a child, the felony level, which is a possible 10-year felony. So generally the rule is going to be that those depositions aren't taken. However, they could be possibly taken by agreement upon the parties, or if the court directs it to be taken. And then there's certain conditions if that's the case. The court would have to find that the testimony of the child is necessary to assist the trial, that the evidence sought is not reasonably available by any other means, and that the probative value of the testimony outweighs the potential detriment to the child of going through the deposition. And then if a deposition is going to be taken of the child under those circumstances, the court is required to appoint an attorney for the child and also to issue a protective order with respect to the child to protect them from emotional harm, unnecessary annoyance, embarrassment, oppression, invasion of privacy, or undue burden of expense or waste of time. But I'm going really quickly and Ken's looking at me, so I have to be downstairs in just a few minutes. So, but I'll be back another time. You'll be hearing this a lot.
I got your message.
So section 2 is moving on to the amendment to the hearsay rule. So hearsay, and I'm just going to read to you the way that the court rules define it in Vermont. Hearsay is a statement other than one made by the declarant while testifying at a trial or hearing, offered in evidence to prove the truth of a matter asserted. So I think an easy way for folks to understand is it's kind of like secondhand evidence. You're not hearing it directly from the person, right? So, and because the person being quoted or spoken about isn't present, it makes determining the credibility of that statement difficult. Thus, generally, hearsay statements are not admissible, but there are a lot of exceptions to that. And so Rule 804A of the Vermont Rules of Evidence is one of those exceptions, applying to hearsay statements by a child 12 years of age or under, if the child is the victim of a sexual offense. And so the amendment to Section 2 is similar into 1, which is saying where there are these special rules regarding children on sexual offenses, we're also adding the offense of cruelty to a child if serious bodily injury was involved. So to assure credibility, there's certain things that the court has to look to. The statements must not have been made in preparation for some type of legal proceeding. The child has to be available to testify in court, and the time, content, and circumstances of statements have to provide substantial indicia of trustworthiness. I did want to just mention, so there is another rule, Rule 807, that has to do with being able to take certain depositions, and I should have mentioned this earlier, around do like a closed circuit TV or having kids testify out of court. And I think that probably once we kind of start to dig into this, I think we need to add a little cross-reference there, and I can draw that up and then we can talk about it later with the witnesses. But I just wanted to mention that.
Ask a quick question.
Gotta be quick.
Okay, if we're gonna come, I'll revisit it.
Okay.
I'm just confused.
I got one more section.
Okay, go ahead.
Sorry. So Section 3 is amending your existing statute with regard to special investigation units. And there is a requirement that is added on page 6. You'll see this new language on subsection B. My understanding from the witnesses earlier was that this is really just kind of codifying existing practice, so that especially if folks involved with special investigation unit are doing an interview of a child related to one of the offenses, and you'll see kind of the offenses that they typically investigate, those are listed under current law on page 5, that those interviews are to be electronically recorded.
Excellent. And I'm sure we'll have lots of questions for when you get back.
Right. And like I said, I'll do a little document that will kind of provide you with the links to the rules, as well as the links to cruelty to a child and the definition of serious bodily injury and some of those other things. So it'll just be a little easier for you guys to look at the laws that are referenced here.
Perfect. And you don't even have to run to get those.
That's good, because I didn't wear my running shoes.
Okay, thank you.
Sure.
So we're going to take a slight detour for the next half hour. If my witnesses get here. On page 121. And what I'm going to do, because I don't think we want to print this out. Okay, we haven't printed out. Okay, well, we'll take those. Thank you. It's nice. So,
I was gonna print it out.
well, the thing is that we're only looking at 2 pages of this 81-page bill.
Can I leave for me to compost this? I think it's gone over and there's a smell.
Oh, is that what
I
smells?
think that's what it is.
Okay, I was wondering. Yes, thank you.
I also opened the refrigerator.
And
Okay,
I didn't see any.
I don't know. What do you think?
I'll
stay
right
yeah.
I think you should leave it there for another week until you figure it out.
I'll take for a minute to come out.
Richard, I'm sure that's.
It must be the refrigerator.
You have all 21?
Yes.
Like,
I'm good. Well, I mean, I think one of, there's not.
I think that,
there's enough
I
going.
think there's.
I've talked about this still so much.
Great, like,
For presentations, I've talked to Jerome's Rutland Rev, talked about it a bunch of times. Just on this. Is, Brett Priestley presented to,
But there's not much in there.
your copy today, and, that's our different presentations.
Your copy?
By no means.
Right. I know that you want to hear this bill.
Yeah, I think everyone on this side has one.
Okay.
That's not
It's the broccoli.
I was saying, that's a refrigerator.
Someone's current broccoli.
Doesn't matter.
I move that the broccoli be composted.
I second that.
Big personality. Right. Yeah.
Have to suffer enough of it.
Mag.
So, we're turning to a fairly narrow issue, for us, in H 121. Let me see what. Second. Page 21, which is an act relating to enhancing consumer privacy. You all can look to page 55 in particular, and we're really looking to understand the impact, if any, to the court. But before we have Judge Zone testify, we'll start with a general understanding of this bill, and then also specifically with this private right of action. We'll invite Chris Curtis from the Attorney General's office to join us to do that. It's H 121,
Did you say page 55?
page 55.
But we don't have a.
It's 32. I have a 50.
Okay, so do you have it as introduced? So let me, that's okay. I'm going to email the correct version to you, and you can probably just look at that page online. So
It's grown.
Yeah, about.
it has grown since it was introduced, I do believe. So I'm sorry, I'm gonna email this to everybody. Hopefully that all works. But why don't you go ahead, because as people are tracking this down on their email and
Certainly. Thank you, Mr. Chair, members of the committee. For the record, my name is Christopher Curtis. I'm an Assistant Attorney General for the state of Vermont, and I'm the Director of our Consumer Assistance Program. The Consumer Assistance Program is part of our Environmental and Public Protection Division, which includes our Consumer Protection Unit. And we are the home for all of the thousands of questions, concerns, complaints that Vermonters might have about commercial transactions they're engaged in. So that is the place where we take complaints and work with consumers to resolve them. And sometimes they lead to investigations or enforcement actions where violations of the Consumer Protection Act are identified. It's my pleasure to be with you all here this morning to talk about H 121, which is an act related to data privacy. Just by way of context, to step back and provide you with a very brief overview. This country has a long history and tradition of respecting citizen privacy, and that's enshrined in our Fourth Amendment protections from unreasonable searches and seizures without a warrant. There are criminal codes and statutes that relate to everything from peeping toms to invasion of privacy on the grounds of your property or your home. And where the law is beginning to catch up is on the commercial side of consumer privacy. So for decades now, there has been a massive trove of consumer information as more and more commercial transactions go online via the internet. That has just become the way that people engage with commerce. It's frictionless, it's easy to engage in transaction, and there are just massive amounts of data out there about every single one of us. And it's everything from your name and address and publicly available information to credit card numbers, social security numbers, and others. So these have become attractive targets for fraudsters and criminal enterprises, but they also have become the object of business models that deal in transactions involving consumer data. And that data is traded almost like a commodity among various actors in the commercial space. Many consumers are wholly unaware of this facet of the transaction. When you go online and you make a purchase, you might assume you have a direct connection to that entity and they're using it simply to facilitate your purchase of a good or a service. However, we now know that a lot of the data that is collected about consumers can be useful in other ways, sometimes for legitimate purposes, but sometimes in ways that consumers don't have a reasonable expectation that would play out that way. So, for example, there are data brokers, and this legislature was the first in the nation to create a data broker registry with some compelled reporting from the data broker industry that would alert consumers to the kinds of data that's collected about them and how that data is used, and to provide consumers with some information about whether or if certain opt-outs for marketing purposes or other purposes might be available to them, and if so, how to take advantage of that. H121 is essentially the new frontier in consumer protection. Following many other jurisdictions in the absence of a federal regime, Vermont is now considering, you all are considering this bill before you, how to provide some guardrails for consumers so that those opt-outs or requests for deletion of certain data provide you, the consumer, with more control over what's happening with the information about you. This bill would give people the opportunity to contact businesses with whom they do engage regularly, or perhaps if they discover that a data broker has their information, it would provide them with certain rights, and it would put certain obligations on the controllers of that data to honor those kinds of requests, to opt out or delete certain information about them in certain cases. And there's a lengthy list of exemptions, and there are some federal laws that control where we wouldn't want certain data to be deleted. There's an exemption, of course, for government, because we can't have people saying just opt me out of a certain governmental program or service. That's a function of our daily civic lives, and the government needs that information. So there are reasonable expectations there. But in terms of the data that's trafficked by commercial entities, this would provide consumers with more choice and more control. So that's the big picture, 50,000-foot view of what's before you. There's been a lot of interest in the enforcement provision of the bill. The Attorney General requested, and you'll see on page 55, the very first line is to say, we simply want to create clarity and extend the same protections that already exist in Title IX under the Consumer Protection Act, and we're going to extend it to this new landscape of data protections for consumers. This is a consumer protection bill. It's in Title IX. It would make sense that the same enforcement or penalty provisions that apply to every other commercial transaction in day-to-day life is also reflected here when it comes to consumer protections for data privacy. So that's the very first thing you'll notice, is it simply says, a person who violates this chapter or rules adopted pursuant to it commits an unfair and deceptive act in commerce in violation of Section 2453. That is the Consumer Protection Act. So that's entirely consistent. You're just telling consumers and businesses, we're not changing the rules on you. This is how it's going to play out. This is how it will apply. So that's for parity and consistency, so that everybody knows here are the rules of the road. And if you violate this, it's going to be the same as what we already have under Title IX. Now, there is a second part of this, and this will be of interest to your committee. And that says that a consumer harmed by a violation may bring an action in Superior Court for the greater of either $1,000 or actual damages. Typically, in the consumer protection context, it's the actual damages that accrue to the consumer. What's interesting and new and different, and the reason that this is in here, this is called statutory damages provision. And that happens when damages cannot be easily ascertained. So you might find that, for example, in copyright infringement cases, where there might be an articulation of a statutory damages, a framework under which people can understand what the value is of the infraction. With data, the consumer may not know for weeks or months or even years what the actual damage to them might be if their identity is at risk. So if there's a violation and a consumer understands it and finds out about that, and there's an enforcement action pursuant to a private right of action, this would tell the courts, and it would tell the consumer, and it would tell the businesses that there's a limitation here in terms of the damages you can request if you can't articulate any actual harms to yourself. I would say that in Illinois, for example, they have a statutory damages provision for their Biometric Information Privacy Act, which is sort of a subset of data protection writ large. That's as much as $5,000 per violation. So this is more modest. They have two in Illinois. They have two. They have one that's a $1,000 standard if it's just negligent behavior, but it's $5,000 if it's willful or intentional. So just in your minds, you can say this is not particularly novel. It's been done in other jurisdictions. Washington state recently passed a medical privacy bill. They also have a private right of action contained in that bill as well. So I think there's more interest in extending those Consumer Protection Act provisions for consumers so that they have remedies. This is a way to articulate it so that there's a limit both for businesses and that there's an articulated value so consumer knows what it means. California recently also, by the way, just in data breach incidents, which again is sort of a subset of some of these privacy matters, they've come up with a liquidated damages provision or statutory damages provision of $100 per violation if there's a data breach. So consumers would be able to get $100 if you get a notice of a data breach. You'd be eligible to say, well, that's the value of that. I might need to pay to get some identity theft protection or something like that. So so that's the second thing you'll notice about this. You'll note in that section, subsection 2, that there is a right to cure. So a consumer can't just go out and say, oh, I made a request and you denied the request or you didn't respond to me. And so now you've violated and I have a right to take you to court. 60 days is a reasonable time in which the average business can respond to a consumer request to opt out of whatever service they provide or delete their information if there's a request and it's subject to the provisions of the statute. So it gives a lot of time, a long runway, so that the business has time to exhaust and that there's sort of an administrative remedy before a complaint can be filed. So that's a protection and a safeguard. I would call this a smart right of action because unlike Illinois or some other jurisdictions that haven't deployed that, this is an opportunity to cure. So it gives the business time to respond. And I think Vermont quite wisely has indicated, I heard somebody say at one point, this isn't a game of gotcha. This is about best practices and about providing consumer choice and control.
Thank you for this. Very interesting. And I'm not familiar really with right of action. And so I'm curious if you can, I understand what we're saying, but if this plays out and say there's a person that's like, yep, my data was shared, I've given you the 60 days, it's still not fixed. What is the action? I don't know if there's a short version you can give of like, what would I do? Who would I contact? Like, is it clear how I would be able to execute that?
That's a great question. So it might be that you talk to an attorney and secure private counsel. However, I would note that because of the amount of the statutory damages here, so as to you personally, it also might be the thing if you really felt aggrieved, might be better suited to small claims court. Small claims court is for smaller matters where the dollars at issue are not astronomical. So if really the business felt like they, would not comply with your request, or I suppose in the rare instance where the business is saying, hey, we're subject to one of the exemptions, so we actually can't honor your request, and here's why, they would have to tell you that. If a consumer was not willing to accept that explanation and they wanted to pursue it, they would, for example, perhaps take that to small claims court, and then a judge would decide, yes, there's an exemption here, and so your claim has no merit. Thank you. I'm sorry. Or they might say, well, we're not so sure that the exemption really applies. You actually should have complied with the request, but a judge would make that decision. But these are relatively modest amounts. And one thing I would note for the committee, we have historically, you all took lengthy testimony over a period of years and ultimately passed some really great improvements to what's happening in the home residential contracting community by passing some modest regulation, and have provided our CAP program with a staff person just to deal with home improvement complaints. We have a devil of a time finding private counsel who will take home improvement complaints, even of $20,000, $30,000, $40,000, $50,000, because the amount of time and legal work that might go into a civil process like that can take a significant amount of time and resources may not even sort of justify the billing that private counsel might need to justify their expense. So for a very modest amount like this, unless there was a major breach of protocol or breach of the law, in which case you might raise more serious questions for you about what's happening with people's data, that would probably be a larger actor with perhaps many thousands of people. That might be the kind of thing where private counsel would be interested in getting involved and pursuing claims of violations on behalf of a large group of people who might be aggrieved or who might have suffered some harms.
But otherwise, small claims court, probably
That could be one option.
And I don't know if you know the answer to this, but in states where this has been implemented or similar things, have they seen numbers like small claims court goes way up, or, is there any data on that?
Yes, it's a great question. And there's been a lot of excitement around what's happened in Illinois, for example. So in Illinois, there was a particular court ruling that said two things. They said, one, the statute of limitations is our standard statute of limitations, so it goes back 5 years. So it cast a longer net of how many people could go back and say, was there a violation? And two, they said, every time, it's not just a one-time per consumer violation in terms of either getting consent or the use of the data, but it's like every time. So there was a case brought in Illinois relating to employees of an employer, and every time they scanned like a thumbprint, I think it was, to get access to do their timekeeping or get access to the where they were working. And so the court's interpretation of their law was basically like every time they scanned a thumb for your however many employees, like every single time you did that for a period of days and weeks and months, like that's a violation for each and every one. So it was like this astronomical, kind of a thing. But I think two things that are different. One is that, of course, in Illinois, they didn't have right to cure. So in Vermont, you would. So if an employer got word that there was a question or concern, they would have time to be responsive and work that out. Two, I believe we have an exemption for employers or for employee use. So that's not a consumer as we typically think of consumer, which is somebody that's just engaged in a financial transaction. So there are some differences between the Illinois law and the Vermont law. And then finally, we have the, much more modest or a smaller, amount per violation. So, we don't know sort of who might try to sort of, seek a remedy under this. But I think the cure provision is really ultimately the safeguard that prevents a rush to the courthouse, because it gives businesses really an ample period of time in which to be responsive to the consumer question or concern.
Thank you. I appreciate that context.
You're welcome.
Phil and Barbara.
Thanks. So under this law, because I was sort of thinking a little about this before you brought it up, in a situation where there was not a curing, as you explained, would each thumbprint be an independent violation? Is each act a violation, or is it sort of the broader, the collecting of the data that's the violation?
Well, it depends, because in some instances, I think the most common instance is where consumers want to exert control over their data. They're going to make the request for the deletion. And there's a significant period of time. I think they get 45 days in which to respond to the consumer, because they have to be able to look for the data and what's maybe associated with the data and so on. So they get that period of time, and then they get the 60 days before you can go to court. So there's actually a substantial period of time baked into the system to say, I mean, that's a one-time request. You don't necessarily, I mean, I suppose they might make multiple requests if they feel like they're not getting through the customer service line, or they haven't gotten some auto response from the checkbox that a company might offer. It's becoming increasingly common. I suspect you all know, when you go online now, there's very frequently some kind of a pop-up that will tell you you're either agreeing to certain terms and conditions, or maybe you don't agree to certain terms and conditions. So, but I think once a request is made, the reasonable interpretation is like that request is the one that carries you through the whole time period. I can't, as a consumer, seek advantage by saying, well, I'm going to request every single day during this entire cure period. That would be an unreasonable interpretation of the statute.
My other comment, it's not really a question, as I was looking at, the subsection 2 here. And I feel the way that it's worded makes it unclear if, for the condition, if the consumer has notified the controller or processor of the violation and the controller or processor fails to cure the violation within 60 days following receipt of the notice of violation. To me, it's unclear if the dependent clause is reasonable costs and attorney's fees, or if the dependent clause is actual damages, injunctive release, punitive damages. And the reason for that is because right before we get there, we have punitive damages in the case of an intentional violation, which contains an internal dependent clause. And so that makes it unclear if what's the dependent clause there. And so I don't think this is anything that we have to deal with now, something the Senate could deal with or something. But I feel like there's a better way to word this, such as if the consumer has notified the controller or processor, blah, 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 comma, and then go into that. Because I'm worried as it's phrased right now, it could lead to argument. Can you file the suit and just not seek the attorney's fees without the cure period? So I would suggest rearranging that.
Great. I think the one consistent drumbeat I've heard from the Commerce Committee and from others is we are always open to continue the conversation if there's a more artful or a clear way to express the intent. Definitely happy to take that up and continue that. So it's a fair point and a great one to take up with the drafters as well, your legislative council, because if they obviously they have an interest in helping you to be as clear as possible. So it's a good thought.
Thanks.
Barbara.
So I have a few questions because I'm still trying to figure out, it feels like, is it bigger than a bread box, kind of like in terms of what this bill covers? So is the statute of limitations from when you find out that, or is when the breach happens? So if you don't know that it happens for a while, I guess I'm just wondering how that's defined.
Yeah, so the Vermont statute of limitations with most consumer claims, and for this certainly would be 6 years. So I think it would be, probably when the consumer reasonably knows or should have known. That would be the marker. It'll be fact specific, just like so many things in the law.
So, for example, I know we talked about government being exempt. Like a couple of years ago, there was the big DOL unemployment breach that happened. So they would be exempt from people bringing action?
Yes, and they would likely anyway under the state's immunity. I think the point would be, the state cannot really honor or balance the sort of twin imperatives of someone saying, on the one hand, I really want a driver's license and I want the privileges that extend to having a driver's license. But oh, by the way, once I have it, I want you to delete all my information from the DMV database. I mean, that's just, you can't reconcile those two things. And it's also, I would say from a government perspective, there are health and safety considerations, there's public safety considerations. It's not a traditional sort of consumer to commercial actor relationship. That's what this bill does. This bill is under Title IX, so it's commerce and trade. And while there are sort of some commercial aspects to engagement with government, it's usually the government has an obligation to provide certain goods and services to its citizens in a particular context. So just because there's an exchange of consideration or money to pay a fee that's required by statute, the state would have a really difficult time honoring a request to, delete information here, there, and everywhere, only to then later find out that the citizen actually needed that information in another context, or the government needed that information in other contexts to be able to ensure public safety writ large. So that's the reason for that.
Does it include local businesses who text or email information that's not encrypted, like credit card numbers or?
It depends. So for small businesses, you have to have at least 6,500. For small businesses that are just doing business locally, it's very likely that this wouldn't even necessarily apply to them.
What's the 6,500 in sales?
In individual data held about individual consumers. Yeah. And that's true for other states have adopted that approach too, of having a population threshold or population.
Does it include, I'm assuming it does, but does it include being hatched, like not having adequate protections in place at your site of business? So you weren't selling it, but you didn't take reasonable protections.
That's already a consideration under our data breach protocols. So I would say there's nothing new or particularly relevant there because we already take the position that in some cases where companies assure the public or their members that they have certain data protections in place, and then come to find out that they did not, or they did not deploy them, and there's a breach, that can be unfair conduct, and we already investigate those. DFR does with its regulated entities as well.
Good to know. And how does a business cure it if something already happened?
Well, so I think the cure provision comes at the consumer request. So it might be that, for example, one way a consumer becomes aware of a company that's holding its data is they get a notice, because companies are required to give notice in the event of a data breach. It's true your data might be out there. At that point, you, the consumer, having been advised that this company is holding your data, you might take the remedial step of saying, I don't like that anymore. And in addition to now taking steps to protect my identity, I'm also directing you, the company, to delete my data, any data you have about me, to ensure that this doesn't happen again, because I don't view you as a trustworthy commercial actor anymore. So you can't go back in time. If there's a data breach, people are going to have to take affirmative steps to protect themselves. What this will do is it will provide for some data minimization. That's part of the bill. And it will provide consumers with the information that they need to say, potentially there might be people who do want to limit what's out there about them, and they might start to go through and contact businesses that they deal with regularly to say, don't sell my information, don't share it, or delete it if that's permitted under the act.
My last question is, and this may be covered under the current law that you just recommended or spoke up. So this seems like it's a common situation that happens where I had all these charges that were not that I did not make. And when I inquired about it, they're like, did you use a credit card at a gas station? And so I don't know if pumps, or when you're like using your, like if that is one of the areas where you can request a cure in terms of not storing your information.
That's a great example of the use of what are colloquially referred to as skimmers that criminals use, and they actually attach them to the pumps so that every time somebody runs a credit card, typically the station owner is unaware. So the skimmers or the criminal elements are getting access to that data. That's a criminal activity. So that would be pursued by law enforcement on any leads they have about who perpetrated the crime. Hopefully there are cameras and they can identify other individuals or perhaps recover one of the machines and do that. But that would not be on the business itself, because the business is not the controller of that data. So interesting example, but one really not contemplated by this, because that would be under the criminal statutes.
What's a notice of violation?
Great question. So that will be a requirement of the company to provide to the consumer. So they have to have an easy way to notify the company that they're making their request, and subsequently, to contact the business to tell them.
So who issues the notice of violation? So if I'm a consumer and I am notified, I find out through a news report that a company I do business with has a data privacy violation, and I want to sue them. And so I have to notify them of that violation, right?
Yeah, so it's a request to opt out or delete the information that you may have. So that's a notice.
Okay.
The company, they have to provide that to you. So now they're on notice and they have this cure period to resolve it or respond to you. They may respond in some instances with something that says, for example, if you're talking to an entity that's excluded or they have a data level exclusion because it's for a particular use, the response that you may get as a consumer is, we're exempt from this particular provision because we use this for a particular purpose. And the law allows us to be able to do that. So we can't honor the request. Then the consumer might say, well, I don't believe that's true, or I don't think that's the way you've been using the data, or what. So then there's a controversy and a dispute. But you'd have to exhaust that 60-day cure period in addition to having made that complaint essentially to the business.
So the notice violation comes from me to the company.
Mm-hmm.
Does my notice of violation have to include a request for cure, or can I just simply say you have violated my rights?
I think however the business extends to you the notice, that's going to be the sign to the business that you've made a request and they're supposed to honor it.
So you mean the business extends to me the notice? I thought I was issuing the notice.
Well, yeah, but the business has to extend to you through its either through its website, which would be the most common way for online transactions, or provide to consumers an easily identifiable way to make these claims.
Okay.
So there will be a checkbox or something extended to, or an email that's extended to consumers that you can take advantage of to say, I'm registering my intent to have you respect my wishes vis-a-vis my data.
But could I, independently of that, let's say I believe that my rights were violated, in a way contemplated by this chapter, could I or my attorney write a letter to them say, I am putting you on notice that I believe you have violated section XYZ?
Certainly.
Okay.
Yeah.
Great.
Yeah.
And so
the Attorney General might as well. We haven't gotten to that section, but the Attorney General does have the power to issue notices of violation, and we would do that directly to the company, either to their general counsel or to the custodian or the agent.
great. That was the next question, actually, because I saw that there. That's where I was a little confused and just wanted to ensure that a consumer could issue that as well to a company. It's not dependent on the Attorney General, like in, I'm thinking like in employment law and things like that. You actually have to go and make a complaint and get sort of a right to sue letter. So there's no right to sue letter here. It's just so long as you issue the notice violation, 60 days are up, the cure is not to your satisfaction, then you can go and go to court with that.
Typically, yeah, we would call that a demand letter, and that would normally be, once the exhaustion period has run or the cure period has run, that would probably be the first thing that happens, say you didn't respect my rights and now I'm putting you on notice. Next step is going to happen.
All right, so you can give us a 2-minute version of the rest of this, because I think that was probably the heart of what we needed to hear from, because then we'll get to Judge Zoning after that.
Certainly. The only other thing I would just add, so the Attorney General does have their typical standard CPA enforcement rights, Consumer Protection Act enforcement rights pursuant to this. There was some discussion about should the Attorney General have to respect a cure period. And you'll note that there is not a cure period because, again, we don't have a waiting period for other kinds of violations. And if there was something that was big enough or serious enough, and now we're talking about data that might be trafficked in the context of like artificial intelligence or deep fake videos that was not authorized by consumers, that might be so serious that the Attorney General needs to intervene immediately. And so we wanted to preserve that power for the Attorney General. It's consistent with what already exists under existing law, but there are data problems that are so serious they require immediate intervention, and it makes sense not to tie the hands of law enforcement officials to be able to seek a remedy immediately and put the company on notice that something has gone seriously awry. So that's just, that's why there is no 60-day waiting period for the Attorney General's office. But for average consumers, we wanted to make sure that businesses have a chance to respond in a reasonable fashion. The only last thing I would leave you with is Connecticut has deployed a Data Privacy Act, and they issued a report after the first 6 months of implementation. And I think they don't have private right of action, but the complaints go to the Attorney General's office. In a state with 6 times our population, I think they had 30 consumer complaints, if my recollection of their report is correct. We have a reporting requirement, so we'll be reporting back to lawmakers about, what we find, what we learn about, how the law is deployed. But I think, that translates to 60 complaints in a year for them. If you just extrapolate that out, in Vermont, that would be about 10 complaints. And the point is, right, that for the most part, you don't have a problem until you know you have a problem. I think it's very unlikely that the average consumer is suddenly going to spend hours and hours combing through the internet, every site they've been to, every purchase they made to say, opt me out, delete my data. Most people want their average online stores to keep their data so they can continue to have easy use of, buying a product, right? But if you get a notice of data breach, if you realize something is really wrong with, or maybe hackers have access to their site and you're getting spam emails, maybe then you say, opt me out, delete my data. So it'll be the individual cases very likely. And that's sort of what's reflected in the Connecticut experience, right? They only had 30 in a state with, 3.6 million people. They had 30 complaints because most people, until there's really a problem, they're going to kind of continue with their use of data as it's currently constructed. But this will give additional rights and it will give additional responsibilities to certain businesses. So I won't take up more of your time. I know you're short
I'm
on
going to
time.
give Tom Burt the last question. Go ahead, Tom.
Yeah, thank you. Chris, good to see you. It's been a couple of years, I think. You used to be a frequent flyer in committee.
Yes, good morning, Representative Burdick.
Anyway, I'm going to assume that this is a lot closer to Illinois than it is to Washington, California, or Connecticut, and the reason being is that you made more comparisons. So, and one of my questions is, what's happened in Illinois as far as the court cases go? I mean, as everybody knows, I guess you could say, is that we're kind of in dire straits here in the state of Vermont with our backlog, and personally, I would have trouble adding anything to it at all, until we did get it caught up, which is probably going to be a couple of years anyway. And my other question is how long has Illinois been doing this? And so how much information have they gathered?
Great question. I'll try to be as brief as I can. And then if you have other questions about this, I mentioned Illinois just specific for two reasons. One, because I figured that would be the one place where people say, well, there has been a lot of litigation here. Of course, it's one of only a small handful of states, I think 3, that have specific biometric information privacy acts. They're the only one to have a private right of action. So there, of course, has been more litigation there just through experience. There was a spike after the case that I mentioned before that kind of expanded how they interpret their statute. But again, part of the reason I brought it up is because Vermont's example, very different what's before you, because we have a cure period, Illinois does not. So this will give Vermont employers and other businesses, frankly, an opportunity to sort of exhaust administrative remedies, give people what they're asking for without having a risk of liability through the courts. And it really will be in the extreme circumstances where a company cannot or will not respond to consumers where there might be a question of violation. So it's a great example for that reason, because there are some elements that are likely to be raised to say, oh, they did rush to the courts in Illinois. But Vermont's, what you have before you is actually very different than what Illinois did. And so I think that is a respect for the business community and getting away from trying to say, consumers can have this immediate right conferred upon them that would create a burden for the court system.
And how long ago did Illinois implement this?
I think they adopted the law in maybe 2008, if memory serves, but I'll reserve the right to correct the specific year. So it's been in force in effect for a long time. But what happened is, as technology caught up to that law, then they began to be aware that there were more and more problems with responding to consumers, and that a lot of businesses weren't getting consent from consumers to use their data. So there was a little catch up, between technology and the law as was passed very early on. And I think Vermont, quite wisely, has learned from the Illinois experience.
Great, thank you.
Great, thank you very much, Chris. Okay.
I can answer any questions offline if you need me for anything.
Great, thank you. Judge Zone, if you could weigh in on H-121, thank you for being here.
Thank you. Tom Zone, Chief Superior Judge. I would note that I saw this bill yesterday afternoon, and Mr. Curtis was kind enough to visit with me and chat about it for a few minutes. Since then, I've had an opportunity to take a deeper dive and think about it a little bit more. The phrase "new frontier" was one that jumps out at me when we look at this type of bill. And I think what Mr. Curtis just touched on was the technology out in Illinois. Technology in these areas has kind of caught up to the law. And I point that out because anytime we're dealing with the new frontier, anytime we're dealing with the increases in technology, and we're going to say that we're going to use that as the foundation for lawsuits, it causes me to say, I don't know what the impact is going to be. I've checked with the trial court operations. I've talked to some other judges, and I'm aware of what happened in Connecticut. And I can say, well, Connecticut hasn't had that many, but they don't have a private cause of action. So there's less incentive for someone to file a case because maybe they look at it and think, well, the attorney general is not going to do anything. For me, to put money in my pocket, as opposed to our statute, which now says somebody can get $1,000 plus the attorney can get attorney's fees. And so when we look at something like this, it's very difficult to assess, is this going to be spawning a cottage industry of attorneys who are going to advertise in Vermont and try to find these violations to bring cases? We saw different claims in federal court. There still is something called the Fair Debt Collection Practices Act. That's somewhat similar in that you can get $1,000 for actual damages and attorney's fees. And many times those cases became more about the attorney's fees. And you can see class actions sometimes being filed that the individual litigants don't get much, but the attorney's fees can be viewed as potentially driving those cases. And so I don't know if there's going to be a situation where this bill that's enacted is going to actually cause attorneys and citizens to say, boy, we want to really pursue this. And if that's the case, it does have the potential to be a lot of cases. But I can't say that's going to happen for where we are now. There is the cure period, which does seem to minimize the risk. However, there were some questions asked earlier, and I just common sense in my assessment would be that how many times have we tried to get customer service on some of these internet companies or places we've done business with and felt like it's just a circular attempt, that we're not getting anywhere? And so I wonder, is the 60 days really going to get the ability to get the communication in and get something back meaningful? But that's a policy decision. As far as going forward with this type of bill, Representative Andriano raised what I thought was a great point about the language. Is it just that you get reasonable attorney's fees if they've notified and done that? And is that clause only for that section, that last clause for the attorney's fees? I think it could be drafted in a way that is a little clearer. And I would also suggest that if you were going to redraft something like this, that you break it up to make it clear prior to filing. If an individual, if a consumer alleges they are harmed, they must first, do X, and then if they do X and there's no claim and there's no cure, then the following can happen. I think you could spell it out to be much clearer to remove that ambiguity. The other question, and I couldn't tell from Mr. Curtis's testimony, is whether the Attorney General believes this is to be retroactive or not. It's not clearly made retroactive and under the law, unless it's clear that that's the way it's intended. It goes prospectively only. And if this were going to be made retroactive, I would think that actually could be somewhat increase the number of cases that we see, because individual businesses may not have been as attentive. If the intent of this bill is to put businesses on notice, they might, not having been on notice previously, they might not have done what they're supposed to be doing, and therefore it might increase the number of claims coming in for acts prior to its effective date if the intent is retroactive. But if that is the intent, it should clearly spell that out. And the other part I want to touch on, if I understand it, there's the idea that the businesses have to come up with their own forms and then let the consumer know that there's forms and you can use this for notices of violation. If that's the expectation, not sure how much confidence I would have in the fact that all the businesses are going to get that right, which could increase the amount of cases. But that gets me back to the beginning, and that is, I don't know. This is really a policy decision for the legislature on what it wants to do, and it could have significant consequences, and it may have drop in the bucket consequences.
I appreciate that clarity. I'm just kidding. I appreciate that. Not surprising. But Chris want to make a couple clarifications or comments.
So just by, again, Chris Curtis, Attorney General's office. So one is we're going to produce a guidance that's part of the legislation before you to help businesses and consumers understand how the law applies. And again, this is not intended to be a bill that will permit a game of gotcha. So, our view is that this is a new law and it would be prospective, going forward. So this would not be a retroactive where suddenly somebody from 5 or 6 years ago is saying, oh, well, see here now, this is a violation. And secondly, we, of course, as the director of the Consumer Assistance Program, I fully expect that our office, my office, within the Attorney General's office, will be receiving calls from consumers saying, how do I avail myself of the protections of this law? What do we do? The company's not getting back to me. How can I access the company? We do that already to the tune of 8,000 to 12,000 consumer calls a year. So we have a team that stands ready, willing, and able to assist Vermonters that have questions about this. We don't know, as the judge pointed out, how many calls we might be receiving, but a lot of people contact us, and that will be part of our public education about this effort, is to say, if you're a consumer and you have questions or concerns, call our office. We're here to help you. We're here to help you navigate, reach somebody at the business that you're trying to reach, and resolve it. And of course, that's all part and parcel of what we call our letter mediation service, which is try to resolve complaints before they turn into really big complaints. So we would be doing that as a matter of course anyway. And so I'll commit to you as a body that when we get those calls, we'll be helping people try to navigate just as we would with any new consumer law.
I appreciate that. So I guess just a question, Judge Zone. I mean, presumably, if this is prospective, if this is going to not take into, if it's not going to occur until July 1st, I believe the date is, there's presumably a time lag between what we're dealing with, the private right of action that we have here and when we could see things starting to hit the court. Is that a correct statement?
I think so.
Yeah. So we'll get a little better idea of if this is ramping up and if the court needs more resources to address that. In the interim, we're trying to provide the resources to get on top of this backlog as it is. So the timing, even if there is a bunch of cases, hopefully we'll be on top of the backlog by that point anyway. But of course, this is just speculation as well, but something to think about. Yeah, Joe, and then, did you have a question?
I'm just wondering if it would be appropriate to offer an amendment on that section. Because given that I thought it was maybe just me not reading this right, but given Judge Zone sort of, also, said that it could be confusing, does it make sense to offer an amendment on A2 in order to clarify that, or does it make sense to leave it to the Senate?
Yeah, I like the idea of an amendment, but I'll talk to Chair Marcotte to see if I think it should actually come from us. But I'll double check with Chair Marcotte, and if there's anything else if we think about. But we're going to turn to the other bill now because I've had folks waiting. And oh, I'm sorry. Before we go, I apologize. Coach has a comment or a question as well.
Question for Chris. Sorry I wasn't there, but you've been in my ear. So, Chris, your division, I know that there are other entities that provide supports, consumer supports, around the state. UVM does, BLS. Do they coordinate with your division?
Great question. So our consumer assistance program is actually a partnership with the University of Vermont. So we, of course, that's wholly integrated as part of our response system, but we routinely connect with and work with our other sister agencies. So we have a very strong connection to our Department of Financial Regulation, for example. So when questions of common concern arise that potentially touch on their regulated entities and we become aware, we reach out to them. And similarly, if they're getting complaints from consumers that are really Title IX concerns, they'll refer those to us. So we have a strong network within the state to work together, try to do the best we can for our citizens and consumers.
And just quickly, I think it was you that mentioned that it's hard to find private counsel. Or it seems to be. What do you attribute that to? I think a tractor trailer was passing me when I heard that part.
It's just the time and expense and duration of civil litigation, which can be very time consuming and can be very expensive. And so for the consumer to make a determination about how much they may be willing to pay for those services, or for the attorneys to make a cost benefit analysis of whether there's really enough in the amount at issue for them to expend the time and resources. Obviously, if the effort to correct a violation takes longer and is more expensive potentially than what's at issue, for the consumer to begin with, they may be making calculations about really whether it's worth the time and effort to pursue that. And of course, that's just a judgment, private counsel makes every day with respect to the kinds of cases they want to practice. So it can be a challenge.
All right, thank you.
Thank you.
So we're going to turn to S190 and we'll hear from Judge Zone and then Jennifer Pullman, and then we'll take a brief break. So jumping over to another issue. Over to you, Judge Zone on S190, and welcome Kelly and Megan and the other folks, Samantha, who have jumped online as well. Thank you and Diane Wheeler, thank you for your patience. Actually, they're not connected to audio yet. If you could hold off for 1 second, Judge. Waiting for Kelly to get her audio. Maybe she's having technical issues. In any event, so we'll catch up with her when she has her audio. But in any event, we're starting now on S1. We're starting now on S190. As I said, we'll have Judge Zone and Jennifer Pullman, and then we'll take a brief break and get to the rest of the witnesses. So over to you, Judge Zone.
Thank you. I will be very brief. On this bill, we testified in the Senate and we maintain that this is a policy decision and we don't think it's going to have any, if you will, impact in terms of the case numbers we have in the court. It is a provision that adds to existing law, and we think it will work fine within the court system in terms of our ability to address it in the cases where any action may be necessary.
Any questions for Judge Zone? I think that was straightforward. Thank you so very much. And that's why we had you first, because I expected as much. So I appreciate that. So we'll catch up with you the next bill that we take up.
Thank you. Now I'm off to Senate Judiciary to talk about a bill that your committee may be familiar with, H563. So we'll be over there.
Well, good luck downstairs.
Thank you. Have a great day, everyone. Take care.
Thank you. Thank you for being here, Jennifer. Thank you for your patience. These things come up this time of year where we have to jump in and look at something before it hits the floor. So
that's fine. It actually gave me time to recover from walking up the hill, which was a reminder of just how out of shape I am. So good morning. For the record, my name is Jennifer Pullman. I am the director of the Vermont Center for Crime Victim Services, and really I always thank you for taking bills up, but this one is really so important to me, and it is an issue that I've tried to flag and have flagged for over a decade. And it speaks to treating children who have been abused the same in terms of our protections that we provide. And I'm going to get further into that, and want to underscore the conversation that you all had around H173 last week, which was the manipulation bill. And the conversation struck me in terms of this may not be something that applies to a lot of cases, applies to a lot of children.
but to those it does apply to, it will make a lifetime of difference. I also want to thank the committee. Many members of this committee sponsored a companion bill, H 552, and appreciate the support. It's always helpful when you see a companion bill that emphasizes that there is support in terms of both committees of jurisdiction. I've already shared my background and the fact that I have worked with children who've been abused sexually, physically, for multiple decades. And my job has often been to protect them, not just from the abusive situation, but from a system that does not allow for and account for the developmental situation that children are in. Before I delve into this bill, in particular, I really want to highlight the support that is present for this bill. And you will see many pieces of this on the committee page. We have support from the Attorney General's office, from Legal Aid, who I know has reached out to a couple of you individually, from Voices for Vermont's Children, Prevent Child Abuse Vermont, Kids Safe Collaborative, the Office of Child, Youth, and Family Advocate, a longtime GAL who has worked in multiple counties, and all of its Child Advocacy Center and SIU directors. I also have a wonderful team in back of me who you're going to hear from, who represent the state's attorney's office, who are forensic interviewers, who direct the CACs, and also two victim advocates who are going to speak not only in terms of their experience, but they're going to speak for survivors who care for these children, who actually as adults don't even feel safe lending their actual names to this testimony, who are sharing their voice through an advocate as adults. And that should really tell us something. When the adults who care for these children are saying, we don't feel safe, we really need to think about what that means. As for the bill, first, why? Why is this important? For me, what's motivated me on this bill is that, in pursuing this issue, is that our rules and our laws are predicated on a false assumption, which is that somehow children who have suffered serious physical abuse suffer less, have less trauma than children who've been sexually abused. Many of you in this room have been here long enough to recall the conversation with the St. Joseph's orphanage survivors, who many decades later, some of whom experienced this abuse in the 80s, the 70s, still have profound lifelong impacts of that physical abuse. So I think when we reflect on their courage, the fact that they weren't heard, and we think about a common sense approach, it just simply isn't true. It doesn't ring true that we would have this disparity. And for me, as a victim advocate in a profession, I feel like it sends a message to children who've been seriously physically abused that you don't deserve the same protection as children who've been sexually abused. And for me, it's elevating the one and making it make sense. And in fact, there are lots of studies that show that this disparity is not borne out in terms of how we decide who in our laws, who experiences more trauma. And in some ways, many studies say that children who've been seriously physically abused have more psychological impacts, more psychiatric impacts. So again, it's just thinking about what makes sense to us as people. And I also want to mention the brain science. We spend a lot of time in this committee talking about reforms and how we acknowledge the lack of, or the fact that neurological development doesn't really sort of complete its course until somebody's 25. And we think about that in terms of how we provide protection and support and reforms that for individuals who are under 25 who cause harm. And I really want to underscore that for children who have experienced harm, we have to think about that brain science as well. And when we put a child in a room for a deposition, when we put a child in a courtroom and force them to go into that courtroom, think about how that brain science should apply to those who've experienced harm. I do want to reflect also a study that I shared with you on the committee page. It was the report issued in 2014 by the Vermont Citizens Advisory Board. And that was also, that was a report that was created in response to the murders of Desiree Sheldon and Peyton Gerard, all within a couple of months of each other. And the governor appointed additional people to that panel. It was a 22-member multidisciplinary group that met for, I don't even know how many times we met, but I was on that panel. And there were many recommendations that came out of that. One was to make sure that special investigation units are also mandated to handle cases of serious bodily injury to a child. And by serious bodily injury, I just want to briefly read this. That means bodily injury that creates any of the following: a substantial risk of death, a substantial loss or impairment of the function of any bodily member or organ, a substantial impairment of health, or substantial disfigurement. It also includes strangulation. So this is not, these are very serious injuries. And that one recommendation was brought forward and included as a mandate for special investigation units to handle those cases. Everybody agreed the SIUs should be the ones that touch those cases. What you're going to hear is that set up a situation where there's two very different sets of tools for prosecutors and advocates, and they will speak as practitioners to that, because it creates a very different situation depending on what the charge is. One other consensus recommendation, and that's what brings me here, is that that panel recommended, consensus recommendation, that there would be this expansions of the protections that exist for children who've been sexually abused, to include children who've been seriously physically abused. Been in and out of this committee as in a judiciary at different times, and have spoken to this. That one has almost gotten across the finish line a couple of times, but it never has.
Can I just ask a question here? Because my head is like, you said you've been dealing with this for over a decade. So I have a bill in front of me. This isn't already law.
No, it is not. I do, and I'm going to speak to where I think the changes now since 2009, because I was a major champion of why we had these protections put in place with respect to sexual abuse. And I think that the conditions in 2009 are so very different, very, very different, and have changed over the years, that for me, it's very frustrating, as you can tell, and as these pages tell, that we haven't kept pace with what our state of Vermont is actually doing. And
So I'm already frustrated and I'm just getting brought up to date on this, but the 2014 information that you have, still nothing has been done in basically 10 years with physical abuse with kids. That's not already law. Am I hearing this right?
yes, you are. Yes, you are. And again, it has been very frustrating for me. And it's been the thing that literally I have said that before I die, I need to see this go through. This is that. Yes. So
Can I just ask you one more question? How did this not go through a long time ago?
I think as best as I can recall, and I was here in 2009, was that extension to even change Rule 15 and 804A to include children who've been sexually abused was fairly contentious at the time. There were many statements around the fact that this would be heavily litigated. It could be unconstitutional. There would be lots of hearings. None of those took place. So I'm here 15 years later to say that did not take place. I'm also here to say that 15 years later, we have a special investigation unit and a child advocacy center in every single county, and that all of these interviews are recorded. So the landscape has significantly changed. We just haven't kept pace with those changes.
What hasn't changed as far as, and I'm not criticizing you about not getting stuff done. I can see your frustration. What hasn't changed is we're still dealing with kids that we haven't dealt with, that everybody talks about is our most important resource, which it is. And wait, somebody hasn't done their. I'm going to shut up now, and because now I'm understanding more, and I can certainly understand your frustration, and like I'm just absolutely blown away that this is hopefully being taken care of this year. And I understand it completely. So thank you.
Well, and I'm certainly grateful for the committee for taking this up right after crossover, and I am hopeful that we will finally bring this forward. And
Just a quick question. Can you remind me when we changed the statute of limitations, or I mean, not statute of limitations, the hearsay rules and such for the sexual assault?
2009.
That was 2009. Okay, that was that long ago. For some reason, I remembered us dealing with this in the last few years as well, but. Yeah,
No, it was.
I'm probably thinking of the statute of limitations issue instead.
Yes.
Okay.
That was in 2019 when the St. Joseph's survivors came forward.
Right. And we changed the sexual assault, and then last biennium we checked, or last year or last biennium, it's all blur, we changed
Yes, you
physical.
changed child sexual abuse statute of limitations a couple of years before that.
Right,
Then
right.
2019, it was the physical abuse change.
That long ago? Oh, okay.
It seems like that was yesterday. I remember that.
Right. That does seem like yesterday. Anyway, I apologize.
Not at all.
Go ahead.
I appreciate the questions. It means people are listening. I'll just dive a little bit in. I already touched on these issues, but with respect to the rules at issue in the proposal, Rule 15 is that deposition rule. And as you know, most cases are resolved through a plea. 95 to 99% are resolved through pleas. Unfortunately, caregivers of these children who've been seriously physically abused, when presented with the choice, which is no choice at all, that their child can be deposed, and you will hear this from victim advocates who are going to represent these words, that they drop the case. They don't want to go forward because nobody wants their child in a room for a deposition. And frankly, I've worked in the system long enough. If this happened to my child, I would never put them through a deposition at all. And so we have this choice, but it's a false choice that it's a no-brainer for anybody that doesn't want their child to go through cross-examination in a deposition. And I really want to highlight one of the statements that is in the Attorney General's letter, which is also on your committee page, that Vermont is in the minority in terms of providing depositions as of right in terms of other states. So when we think about, when we think about these pieces, I just really want to reflect on the fact that we are in that small minority. And again, that's a statement from the Attorney General's office. So this deposition phase is really critical. Most of these cases do not go to trial anyway, and that you have caregivers who are saying, we're just going to drop the case. We can't move forward. Really want to think about that. I really want to underscore what Attorney Childs hinted at, that this change is not an absolute bar to a deposition. There can still be those findings. There still could be that process in a court wherein the court can order it and can provide some protections for the young person who's being deposed. One of the pieces that's most concerning to me about the current state of Rule 15 is that back in 2009, we worked to make sure that there was a provision under Rule 15, sub 4, sub X, that made sure that pro se defendants could not question individuals in depositions in these particular sensitive cases. So what you have now is that not only do you have a assumption that a child who's been seriously physically abused can be deposed, but there's no protection against the actual person who chooses to be pro se, to be the person that goes in and questions that child. For me, that's unacceptable. And I just think that's an additional area of concern wherein we really need to think about how we bring in protections for children who've been physically abused. I know I have folks in back of me who have court dates and such, so I'll try and go a little bit more quickly. With respect to Rule 804A, that would allow non-testimonial statements of a child to come in. And again, Vermont's not a pioneer, and it would not be a pioneer in expanding this to victims of serious bodily injury. Other states do this. I want to emphasize that these statements are non-testimonial and are not therefore implicating the confrontation clause. In fact, in 2015, in the case of Ohio versus Clark, the United States Supreme Court issued a unanimous decision saying that statements of children are generally non-testimonial. The fact pattern in that case involved a 3-year-old who had made statements to his teacher, and the teacher brought those statements in a court hearing. And the Supreme Court stated, statements by very young children will rarely, if ever, implicate the Confrontation Clause because they do not understand how criminal justice and prosecution work. Furthermore, the court noted the ongoing emergency involving suspected child abuse and that the child's purpose is to get help from a trusted adult or to get away from the abuse. So this would allow statements made to teachers, caregivers, daycare providers, even to medical professionals to come in the case. And it still requires the child to be available. So again, it's not this absolute free-for-all where statements are just coming in. The child still does have to be available. But where you'll hear from other providers and practitioners is even if it doesn't go to trial, it's helpful in terms of strengthening a case. When there's a possibility that a teacher can come on the stand and say, this is what happened, and provide support for the child, it helps to reach a settlement. So it has value in terms of building that case, even if it does not ultimately go to trial. And I just want to underscore that none of these rulings or protections have been overturned to date, and no logical, rational, or legal reason not to extend. I won't belabor this point because I want to get to a place where you can hear from the practitioners, but I do want to just speak to the current landscape. As I already spoke to, in 2009, we were in a very different position than we are today. Our state, and having overseen the child advocacy centers, I can say that our state is the only state in the country that has a child advocacy center that is accredited nationally, is held to very rigorous standards in every single county. All interviews are recorded, and I really want to underscore that when the additional piece to 190 was added, which would be the amendment to the SIU enabling statute, that would require these interviews to be recorded either through video or audio means. That was a language that I worked on with Attorney Paul. It was a suggestion. I absolutely agree with it because first, it is codifying practice, but second, from somebody who really cares about how we treat children, and the purpose of utilizing a child advocacy center and a special investigation unit is to reduce the trauma to the child. A part of that is making sure that we are not asking children to continue to retell and retell and retell their story. So for me, I would be very disturbed to know that something was not recorded. So it represents best practice. And I actually think that this may be an amendment that I care more about than Attorney Paul, because I really want to make sure that we're doing right by children and making sure that we are utilizing the resources that the state has been really intentional about setting up. So in conclusion, you all made a very important change in 2009, and some of the concerns that were raised did not in fact materialize. And for the center, we feel it is really past time that Vermont follow the consensus recommendations from 2014 and recognize that harm is harm and trauma is trauma, and child victims of serious bodily injury deserve to have the same protections as children who've been sexually abused. I appreciate your time, and thank you very much.
Thank you very much. Any questions? And you'll be around if there's other questions.
Oh, yes, I'll be following you pretty closely on this one.
Excellent. So we'll just take a really brief break, 5 minutes, and then we'll get to the rest of our witnesses.